Yeah, good evening everyone. I've just come out of there again, Lavender Hill Magistrates Court. This was a tough one. I think I got called in at about 3 p.m. and the case went on and has just finished now about 6 o'clock. Yeah, lots of complex arguments, and I think I'm going to have to digest it and look through my notes before I give you the full write-up. But yeah, lots of complex stuff going on. Very obstreperous solicitor for the defendants, who didn't seem to know what he was doing, and 3 times seemed to search for the defendant's name, which I didn't think was very professional. Anyway, it's only my opinion. I'll speak to camera again about this one when I've thought about it some more. Ciao.
Hello everyone. First of all, a huge thank you for having me on the channel. My name's Daniel Shansmith. I'm a barrister of England and Wales, and I enjoy helping you to understand law over on my own channel on Black Belt Barrister. So thank you to Mikey for kindly inviting me to give you some commentary on this very interesting taxi case. Now, there's a lot of interesting points brought up in this case. For example, the submission of no case to answer, whether or not the exemption for making a contactless payment applies to taxi drivers, whether or not the statement should have been passed across, as in Mikey's witness statement, and we'll come to that as well a bit later. And so let's talk about the offence itself. I will go through the video, I'll give you my commentary as I go through it, and of course I'll talk about the regulations. So forgive me if you've heard about that a lot already on this channel, but I'll just give you my brief overview on that as well. So first of all, the starting point with these regulations, I feel it necessary to say that the law was amended quite significantly to make it very restrictive with the use of mobile phones or any other device that's capable of interactive communication. And this all started with the case of Director of Public Prosecutions and Barretto, in that he was, Barretto this was filming the collision as he drove along in his car. And this ultimately led to his conviction being quashed because it wasn't quite caught within the legislation as it then was. That was then amended. And Regulation 110 now provides that virtually anything that you can do with a mobile phone is going to be in breach of that regulation. And this is the regulation you can see here. So all of those things that you can see here, checking the time, illuminating the screen, checking notifications, unlocking the device. I mean, this one for me is quite broad in that illuminating the screen, you can't really do anything with the phone unless you've illuminated the screen. And even by touching the screen, at least with mine, it illuminates the screen. So you can't even touch it if it's in your hand. And so using a mobile phone to do any of these things, which includes pretty much anything you can think of, is going to be in breach of these regulations. And it's a very strict and heavy penalty. And so the question arises as to whether the contactless payment applies to this taxi driver case, as we'll come to in a moment. But let's watch the video first, and I'll give you my commentary as we go along through. So move to the video here. I'm not going to play all of the video. You can watch the rest of it in the rest of Mikey's video, but this is my commentary as we go along here. Let's watch it from this point here. Let me turn the volume down slightly. So approaching from the near side rear. And what I will do at some point is zoom in so we can see closer. So you can see there the driver clearly has the phone in his hands. You can clearly see there's a passenger in the back. And approaching the pillar of the door here, looking around and pausing there, you can quite clearly see the driver has the phone in both hands, resting it against the steering wheel, and he's not even touching the steering wheel. One might argue that he's not moving at this point, but if we continue playing on the video, whilst he does eventually grab the steering wheel, he started moving before touching the steering wheel. Now, if we go back for a moment to around about this point here, you can see that these are my observations. Evidentially, this is what I would do when I'm looking through a case to advise a client whether they are guilty of an offence or not. There's clearly a whole queue of traffic here. And whilst there is a footpath, this passenger is clearly sitting in the back and not looking like he's going anywhere. It looks quite fit up, actually. And at one point, you'll spot in a moment that he even checks his watch to check how long it's going to take him to get through this traffic. Now, that's important because from an evidential point of view, one of the arguments was that the driver was taking a payment and therefore shouldn't be guilty of this offence, and it should come within this exemption, which it doesn't for reasons I'll come to in a moment, and the bench didn't accept anyway. But the argument itself as to whether or not the passenger was making payment to get out What do you do when you're a passenger? Well, if you're about to pay, you're getting your wallet out, you're leaning forward, you're talking to the driver, driver is usually talking with you. All of that should happen when the vehicle is stationary. So at any argument whatsoever, the vehicle should be pulled over to the side, should be stationary, and that interaction should happen there. But if we watch this again, there is no visible clue or suggestion that this passenger is anything like looking to get there. He looks at his watch. Look, there's no suggestion that the passenger is ready to get out. There's no real communication at all between the driver and the passenger. All you can see is the driver has the phone in his hands. Now, if we look at the defense argument for a moment that this should have come within the contactless payment exemption, let's look at the wording for that exemption. This provides that a person does not contravene a provision of this regulation if, at the time of the alleged contravention, that person is using the mobile telephone or other device to make a contactless payment for goods or services which is received at the same time or after the contactless payment is made, and the motor vehicle is stationary. So in reverse order, the driver here cannot possibly come within that exemption because a stationary vehicle should have the handbrake applied and ideally should be at the side of the road, not in the middle of the road. So whilst there's a fairly flimsy argument that the vehicle is stationary, that wouldn't be accepted even if this exemption were to apply. But what this exemption to the regulation really means is that if I'm making a contactless payment, at least with mine, with Apple Pay, I will triple click the button on the side and make a payment with it. And that is obviously for coffee or food at a drive-through, and they are provided at the same time. Or it might be for a car wash, for example, and I'm driving through like a drive-through car wash and make a payment like that. Any goods or services that are received at or just after the contactless payment is made. Now, applying that to this situation, if the driver were, which I don't think he was, taking a payment from the passenger, that is taking a payment, not making a payment. And so these regulations have to be read very strictly, which we'll come back to a bit later when we talk about the mental element, the mens rea element to the offence. So in short, even if the driver were taking a payment, in my view, this exemption does not apply. The only way this argument would have worked at all for the driver is if the driver was at the side of the road, parked up, stationary, handbrake on, and actually taking a payment from the passenger. Now, all of this taken together, that is not what is happening here, in my view. Now, it's also interesting to note that there is a significant distance between this vehicle and the vehicles in front. Now, this suggests to me two possible things. One, either that the driver is not paying full attention to the road and has left this sort of gap in front, which is not ideal because it's a queue of traffic. It's only going to extend the overall traffic queue. Or secondly, either consciously or subconsciously, the driver knows that it's not really safe to be close to the vehicle in front whilst using the phone, and therefore, again, is either consciously or subconsciously leaving a gap because he's using his phone. Now, either way, you can clearly see he's using a phone for whatever the purpose that might have been. Now, as to the mens rea element, that being the mental element, this was one argument fairly forcefully put across by the defence, according to Mikey's notes here. There is no mental intention element required for this offence. This is a strict offence, i.e. if you do this thing, you are guilty of the offence. But if we contrast that for a moment with the offence of theft, by way of example, there are 5 elements to theft. It must be the dishonest appropriation of property belonging to another with the intention to permanently deprive that person of it. Now, there's more than one element that has a mental element to it. The dishonest part, dishonesty, has a subjective mental intention element to it, and the 5th one, the intention to deprive. Whereas, if we contrast that with this regulation here, it is strictly worded. No person shall drive a motor vehicle on a road if he is using a handheld mobile telephone or other device. Now, so if he's doing that thing, then you're guilty of the offence, regardless of any intention whatsoever. It's a little bit like the possession of illicit substances. If you have it on your possession, you're guilty of possession. That's the way the law works. Now, as to the argument of no case to answer, all cases, whether they are civil or criminal, are made up of 2 halves, either the prosecution and defence or the claim and defence. 2 halves to the trial. And the reason for that, taking a criminal prosecution by way of example, the prosecution present the prosecution case and then close the prosecution prosecution case, and then the defense bring their case. Now, in between is what we call the halfway point. Now, the submission of no case to answer is often referred to as a half-time submission, because making the application at the end of the prosecution case, a submission of no case to answer suggests that, given all the evidence that's been provided, the bench or a jury should not be able to properly convict on that evidence. Take, for example, if witness evidence is weak, and the term is a fleeting glance taken from the case of Turnbull. So this application for witness evidence is often referred to as a Turnbull submission, i.e. it is weak evidence that should not be left to a jury. Now, a submission of no case to answer might be made in that case in that it would be unsafe to leave that evidence to a jury because it's unreliable evidence. In this case, with all respect to the defense, it was highly unlikely that a submission of no case to answer was ever going to succeed. But also, it's sometimes only made as a potential point of appeal, in that if the application is refused, that might be one point upon which they could appeal a conviction, in that the ruling should have been that there was no case to answer. But obviously, in this case, that didn't happen. And sometimes if we want to look for a little bit more guidance as to how to interpret these regulations or any other piece of legislation, there are often explanatory notes. They are not part of the legislation itself, they are just guidance as to how the court is to interpret these regulations or legislation and to which they will have regard. In this case, it very specifically says that these regulations were amended to widen the scope of the offence to include any use of a mobile phone or interactive communication in the hand whilst driving, and that they remove the requirement that the driver is using the mobile telephone or other device to perform interactive communication function. If you remember the case of DPP and Barretto, that was a very narrow exception in that they argued that the interactive communication was not happening at that point. And as the legislation was then drafted, meant that there was a very neat little loophole through which this case escaped. However, now it's been amended so that regardless of whether these interactive communication functions are active or not, if you are using the device, even for illuminating the screen, then you're in breach of those regulations. But as I say, the only way this taxi driver would have been okay to take the payment by any means of the use of the phone would be if he was pulled over, stationary, parked up, handbrake on, and definitively, unquestionably stopped for the purposes of letting the passenger out and taking the payment. But in this case, in my view, he was in the middle of the road. He was still driving insofar as the court would be concerned. So even if he were taking a payment, that still wouldn't apply here. But as I say, I don't think he was taking a payment. There's no suggestion from looking at it that the passenger was ready to get out, or there was any communication between the passenger and the driver via the payment. It looks very much more like the driver was reading something or going through messages or something like that. So either way, this exemption does not apply in this case because it's for making a contactless payment rather than taking a payment. And even if it did, the vehicle would have to be stationary. And stationary is not met by sitting in the middle of the road. It should be pulled over with the handbrake on, or in the case of a drive-through, in going through a drive-through with the handbrake on. As to the suggestion that the driver was startled by being filmed, that is never going to wash because the driver should be alert and aware at all times. As to the argument that Mikey was shouting at the driver, I heard no such thing during the video. As to the argument regarding the witness statement, clearly the defense wanted to use Mikey's witness statement to poke holes in it for the purposes of cross-examination. Because if there's any inconsistency or if there's any discrepancy that defense could use within that statement to cross-examine Mikey, that might have undermined the prosecution case. However, this being a criminal case where evidence is ordinarily heard orally, and only if statements are agreed, then the statements remain in written form and they are read out for the court as opposed to giving live evidence in court. But in this case, with the prosecution evidence being heard orally by Mikey giving his evidence in court, it is then the opportunity for defense advocates to cross-examine those prosecution witnesses rather than pick apart the written witness statement. This contrasts the situation with a civil claim where the primary evidence is, instead of being oral oral evidence is in writing. That is because of the difference in the burden and standard of proof. Witnesses are trusted to leave their primary evidence to their written witness statement. That will then, with the judge's permission, stand in evidence in chief, and they will then be cross-examined on that witness statement. But that is not the case in criminal cases. Evidence is ordinarily heard orally. And finally, there's no surprise, of course, that the court was unwilling to provide any commentary regarding the committee meeting with Transport for London as to whether or not the driver would lose the green badge. The court is simply not going to make such comments. So I hope you found that overview interesting. There's thousands more videos on my channel if you do wish to watch those. But thank you once again to Mikey for having me on the channel. And with that, I thank you for your kind attention. Bye for now.
Why is it saying 11 minutes? I won't really take it.
Should you be having a clearly lit up phone screen there, my friend? Yeah, you can drop it. Blue charge cable. AT716. LG22YFN with a 3D number plate. 21159. Come on fella, you gotta do better. You know your driver was on his phone, right? Sorry? No, he's just on the phone, so I'll be reporting him to the police. But if I were a taxi passenger, I'd be getting out with someone driving on the phone. No, he's just on the phone, so I'll be reporting him to the police. But if I were a taxi passenger, I'd be getting out with someone driving on the phone. Good morning everyone. So yeah, this is about the taxi driver case that you're about to see, and it was a very interesting case. It took ages, like 2.5 hours, something like that. No, maybe 3. So anyway, essentially I filmed this taxi driver across there in West Carriage Drive in Hyde Park, and His defense was initially that there was no case to answer, and that's because he said he was taking a fare and was stationary. Anyway, just before this, I had my gave my evidence on the stand and was cross-examined, really quite bullishly and powerfully by the defence solicitor. Anyway, the magistrates saw that the taxi was moving on the video. Taking a fare isn't allowed except when completely stationary, and really, it should be in a kind of a drive-through situation. So the defence claimed the case was poorly presented, was very pushy and towards the court and the prosecutor. And the prosecutor had to stand up really strongly against him. Anyway, so the magistrates went out and decided that yes, there was in fact a case to answer, so the trial progressed. Okay, so then the defendant took the stand. He'd been a London licensed taxi driver for 18 months, meaning he has a green badge. He took a passenger from Exhibition Road to Bayswater, and that when I called him, the taxi driver wanted to get out and pay. He gave a mobile phone statement showing that he hadn't made any personal calls from 2:30 till 7 o'clock in the evening. I think I caught him just after 5 o'clock, I can't remember. The driver showed his payment machine, which is one of those little portable devices, and said that he'd put the amount on the machine by using his phone, and that he was allowed to do that because he was taking a payment. So my view on this, thinking to myself, was that why didn't the driver park up and take the payment? Then he could have done so quite legally, and there were empty parking spaces right where I caught him. I thought the exemption of using your phone when stationary was for making contactless payments, not for taking them. But maybe that's not well defined in law. I don't know. I'm not a lawyer. I'll leave that one to the black belt barrister who's offered to make some commentary on this video. Yeah, and then there was some argument about my statement and how the defense wanted to use my statement and the prosecutor refused, basically because the defense had already had a chance to cross-examine me, and I hadn't left the court when I was released from the stand. I went and sat in the witness gallery, so I'd been observing all the proceedings, and that precludes you from giving further evidence, I believe. There's a big argument about that. And then the defense and the taxi driver claimed that I startled him and that he began to drive off simply because I spoke to him. Now, I think if you watch the video, that's not the case. Although it was very close together, he'd already started driving off before he noticed me and before he'd have any chance to react on either the brakes or the accelerator. Apparently, in the defense's summing up, I'm culpable for what the taxi driver did, and that I'm a professional complaining witness and an overly officious citizen, and he's arguing about mens rea, meaning that the taxi driver had to have intended to drive forwards and that he didn't have that because I'd given him a fright. And then pretty much the whole court, the legal advisor and the prosecutor, turned around and said this is a strict liability offence. There's no need for any mens rea, meaning no need for his mental intention to drive forwards, and it wasn't relevant to the case. So quite interesting, really. So the crux of the matter was that the taxi driver wanted to say that he wasn't guilty of a mobile phone driving offence because he was taking a payment and that he wasn't moving. But I think the video evidence shows otherwise, and you're going to see the full video, like from before what I submitted to the court, where you see a WhatsApp gap twice, which tells me he has been using the phone for a long time. I mean, we don't know that, but it seems likely, right? And then the fact that the passenger didn't get out when I was talking to the taxi driver, or for a minute 20 afterwards, as you'll see on my rear camera footage. So the magistrates went away, they made a big... They took some time to decide this, and they came back and basically they said he was guilty. The defense then argued for no endorsements and for special reasons for no endorsements, because it was such a small amount of driving forwards and purportedly presented no risk to others. The magistrates went away, decided on that, and came back and said they would not accept special measures because of the large amount of traffic, because of the pedestrians, lots of pedestrians around, and because it was in a park. So yeah, sadly he lost out. The taxi driver had 3 points already for speeding in 2022, and 3 points before that also, I think, for speeding in 2019, but those had expired, so he was in no danger of losing his license. He was given a fine of £220, the full costs of £620, and a surcharge of £88, and was allowed to pay it back monthly at £100 a month, which I think is very fair. I'm completely fine with that. The solicitor then asked if the bench would be willing to make any comments about this case to the TfL licensing committee, who would be due to be seeing this taxi driver, as to whether he'd be allowed to keep his green badge. And the court said they were not in a position to do that, and it was not something they could offer. So pretty interesting, huh? I thought I'd had enough evidence when I saw the taxi driver simply using it and not when he was stationary. So that means maybe I should have kept on filming for a bit longer before saying anything. I really did not anticipate that this defense would come forwards. So yeah, in light of this, I'd like to pass you over to Daniel Shensmith, my friend, the black belt barrister. He's a really cool guy, and you should subscribe to his channel if you haven't already. He talks about lots of interesting stuff, well outside of just driving law. And he's going to comment on the legal side. Thanks very much. Bye.